all for attending the second of our presentations in this year's Student Scholar Series. The series, as you know, was instituted 13 years ago now in order to recognize notable legal scholarship produced by members of the student body during the previous academic year and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Rebecca Schisler. Before I introduce Rebecca, I'd like to first introduce the respondent to her presentation, John Mueller. I hope I pronounced that correctly. Mr. Mueller is a graduate of the College of William & Mary, where he earned a Bachelor's of Science in Biology, and of the T.C. Williams School of Law at the University of Richmond, where he earned his Juris Doctorate. Mr. Mueller has worked in the litigation department of McGuire Woods and the Environmental and Natural Resources Division of the U.S. Department of Justice, and is currently the first Vice President for Litigation at the Chesapeake Bay Foundation. While at DOJ, Mr. Mueller prosecuted several civil actions enforcing federal environmental laws such as the Clean Air Act, the Clean Water Act, CERCLA, Resource Conservation Recovery Act, and Toxic Substances Control Act. His responsibilities at CBF include coordinating and handling strategic litigation against polluters and governmental entities for failing to comply with federal and state laws and regulations. So we thank him for coming here today and participating in this event. Now let me introduce today's student scholar. Rebecca Schisler is a third-year law student here who's passionate about Maryland public policy. She graduated from Mount St. Mary's University in 2017, where she studied philosophy and sociology. During law school, Rebecca has interned for Montgomery County State's Attorney's Office, Judge Contreras in the United States District Court for D.C., Geico's General Counsel, the Anne Arundel County Office of the Public Defender, and is currently employed at the Maryland Senate. She is an editor for the Law Review here and serves as Vice President for Student Affairs on the Student Bar Association. After graduation, she will be clerking for Judge Mark Crooks in the Anne Arundel County Circuit Court. As a Maryland Eastern Shore native, Rebecca is very excited for the opportunity to share her research on a topic that hits so close to home. So I'll turn the floor over now to Rebecca Schisler for her presentation, the title of which is Shortcomings of the Clean Water Act, a Potential for Progress in the Chesapeake Bay. Rebecca?
This isn't a super flat surface. Thank you all so much for being here today, especially to my respondent, Mr. Mueller, who served as my expert reader throughout this process and critiqued me and was really helpful this whole time. So my paper is about the Chesapeake Bay, and you'll see on the first slide is a photo of Havre de Grace, Maryland, which sits just south of the Conowingo Dam. I'll get into that in a couple of minutes. The point of me having this on my first slide is to show you what it looks like right at the base of that dam. The brown color comes from a lot of things, including sediment and nutrient pollution. So that's just the color of the bay in areas that you might not have seen before. Why did I pick the Chesapeake Bay? So I grew up on the Eastern Shore, right across the street from a seafood facility where people from all over Maryland keep their boats, and a lot of men serve as watermen, and when you see the crabbing trucks and everything deliver the crabs to the local restaurants, I grew up there. This is a little video of my best friend from home doing just that. She's crabbing and on our boat, and this is just to show you when I talk about using the bay and the watermen that depend on it, this is the kind of thing that they're doing every day. This quote comes from a friend of mine who I interviewed as part of my paper, who finished high school and then immediately became a waterman at the place that I grew up across the street from. In talking to him, that really made me sure of this topic and that this is what I wanted to do, because he really stressed how much the bay means to him and how it's his livelihood. And if we don't have the bay healthy, there are thousands of people across Maryland's Eastern Shore that won't have a job. All right, so the first thing that I want to bring to your attention before I get to more of the nitty-gritty legal things going on here is, why are we here? There are 5 dams in the Susquehanna watershed, and the largest one is the Conowingo Dam, which sits right at the bottom of the Susquehanna River and blocks off pollution from New York and Pennsylvania. So it sits right here at the bottom, and all of this here is the Susquehanna watershed. So any pollution that happens in those parts of the states all goes in the Susquehanna River, which then comes into the Chesapeake Bay. Whenever there's heavy rainfall, the floodgates on the Conowingo Dam are opened, and any pollution that had been held back in the Susquehanna River gets sent through the Conowingo Dam into the Chesapeake Bay. A more recent example of this was the week of July 22nd, 2018. The United States received more or less unprecedented torrential rain, and the river reached 3 feet above flood stage, and the 20 floodgates on the Conowingo Dam were opened. The sediment that had been trapped behind the dam, as well as subsequent pollution that was carried downstream, all flowed into the Chesapeake Bay and caused damage throughout the weeks and months that the gates were opened. In Harford County, for example, July 2018 was the wettest month they've ever had on record. And Harford County is one of those counties that's directly affected at the top of Maryland. For a while, the dam was colloquially known as a pollution gate. In recent years, the nickname's truthfulness has diminished as the dam's ability to trap pollution long-term has declined. Because the dam has nearly reached its capacity, it's trapping smaller amounts of incoming sediment, and during large storms, it's sending more silt and attached nutrients over the dam and into the bay more often. The types of pollution that flows into the bay varies, but the two most common types of pollution are nutrients and sediment. Nutrient pollution fuels the growth of harmful algae blooms, which can create dead zones, which really affects marine life within the bay. Sediment pollution clouds the water and blocks light from reaching underwater grasses and smothering the shellfish that live at the bottom of the bay. So in 1947, the Congress enacted the Clean Water Act. Overall, the act has been successful in certain parts of America in the waterways, and the EPA has been able to develop criteria and recommendations for ridding the waters of pollution. The whole point of the act was to restore the nation's waterways from chemical, physical damage, and it made it unlawful for any person to discharge pollution from a point source, we'll get to that, into navigable waters unless a permit was obtained under its provisions. So you can think of it as a long act that's meant to be a guideline for any person or locality or factory that is going to be purposefully putting pollution into any of America's waterways. The act has proven very specific in application with a number of claims that it purportedly does not cover. As such, the determination has been left to courts to ascertain their jurisdiction for many parts of the act. And currently, under the act, Maryland has to go through the EPA administrator in order to hold other states accountable for their pollution. So the photo that I showed you on the last slide with Pennsylvania and New York sending pollution into the Susquehanna watershed, Maryland can't do anything to go to those states directly. Everything that Maryland has to do has to be done through the EPA themselves. That's kind of the showcase for this presentation. That's the issue that I saw and thought there's got to be a better way to do something like that. In practice, what happens is that the federal government bears the main responsibility for rectifying violations that the states have allowed, and the root of the problem is not as addressed as well as it could be in the Clean Water Act. So, the main problem with the Clean Water Act is not that it's not working, but that it can only do what the act was designed to do. And there were certain problems with the Clean Water Act that Congress specifically left out of the legislation to be dealt with by the states. The biggest problem is non-point source pollution. Point source pollution, on the other hand, is the kind of pollution that comes from any discernible, confined, and discrete conveyance, not limited to a pipe, a ditch, a channel, a tunnel, a conduit, and the like, most of which come from things like factories that's then discharged into water. Non-point source pollution, on the other hand, is the pollution that comes as a result of stormwater runoff or heavy rainfall, agriculture runoff, or anything that doesn't come straight from a pipe. Non-point source pollution was specifically left out of the act, and the act only requires a permit for point source pollution. The quote I have here at the bottom is direct language from the act that shows the administrator shall not require a permit under this section for discharges such as stormwater runoff, for mining operations, oil and gas, etc. This is a visual of the differences between point sources and non-point sources. Non-point source pollution is the leading source of pollution in the United States. And you can see why, because non-point source pollution is coming from everything up at the top of the map. The point source pollution comes from the pipes from the factories or the water treatment plants that then gets pumped out into the local water. The same factories that generate point source pollution also generate their fair share of non-point source pollution. But the difference is that those factories can blame rainfall and stormwater runoff for the spread of that pollution. Even taking factories out of the picture, non-point source pollution comes from many other sources, including urban runoff, improperly managed construction sites, livestock, septic systems, and more. So what does this all mean? The first problem with the non-point source pollution is that it comes in the form of stormwater discharges. What happens is the act, given that it only covers point source pollution, has left it to the states to determine what to do with the problem of non-point source pollution. There are a number of claims that the act does not cover, one of them being stormwater discharges. There's even a circuit split in the 4th and the 6th circuits, which could be the topic of an entirely different paper. I can speak to that in brief later on during questions if you'd like to know about it, but the 4th and the 6th circuits really disagree on stormwater discharges and how to handle that as far as the permit goes. So I keep talking about these permits. Under the Clean Water Act, permits are required to discharge point source pollution. And a lot of this comes from what's called MS4s, which are municipal separate storm sewer systems. So a lot of runoff is transported through these systems, and companies can apply for one of these permits and be granted one through the state of Maryland. So the state of Maryland has to develop the criteria for one of these permits and then give them out to companies as they are applied for. A big problem here is that Maryland has been unable to successfully draft a strong permit requirement. Lots of faculties have these permits, and they're given out pretty liberally within Maryland. Excuse me. So a big problem for the Chesapeake Bay in general is the failure of Maryland's government in developing the strong permit for localities, which in turn presents more enforcement issues for those permits when the localities fail to meet them. They're very vague, and there's a lot of requirements that are difficult to understand. So later on in 1987, the Clean Water Act was later amended to include Section 319, which required states to develop best management plans for dealing with pollution and including non-point source pollution. What I mean by that is that the Clean Water Act itself still does not recognize non-point source pollution or give ways to control it, but it has designated particular states, departments of the environment or the equivalent, to determine how best to handle non-point source pollution within those states. So the section ultimately allows for grant assistance to states or territories for activities such as technical assistance, financial assistance, training, education, and demonstration projects to assess the success of specific non-point source implementation projects. Under Section 319, states are allowed to choose the method in which they handle non-point source pollution with very little review or recommendation from the EPA. What that means is that very many states have also developed non-regulatory approaches to non-point source pollution. In the place of an actual regulatory solution administered and enforced by the state, states may allow for voluntary best management practices. That is, the action that the state has decided to take regarding non-point source pollution is in the hands of volunteers, not in the hands of administrators or state officials who have the authority to effect change. In the case of the Chesapeake Bay, where pollution comes from Pennsylvania and New York, in addition to Maryland, Maryland cannot control what Pennsylvania and New York allow into their waters. If Maryland doesn't like what Pennsylvania does, there's no remedy within Maryland to develop a best management practice that will affect another state. Furthermore, the EPA may only approve or disapprove of what the state comes up with and may not promulgate a federal plan in lieu of an adequate state plan. The state comes up with their own, submits it to the EPA, and the EPA will accept it or reject it and can go no further. So what the EPA does is doesn't allow the actual grant money that the state is asking for in promulgating one of these plans. So it's a little bit of a cyclical effort on the part of the states. Another aspect of the Clean Water Act is Section 303, which talks about the implementation system for handling what's called total maximum daily loads. That is, what is the amount of pollution that a certain water body can handle and still keep its function as whatever that water body is supposed to do. Under Section 303, states must identify which waters will remain polluted after technology-based standards are implemented, then prioritize these waters and establish TMDLs so that the waters can meet their applicable water quality standards. A TMDL is basically the combined amount of pollution that the state believes a water body could accept without exceeding the required water quality standards and an allocation of pollution reductions needed from existing sources to meet this target. Some states have implemented TMDLs, and the Chesapeake Bay also has TMDLs designated for it, implemented over the past couple of years. So far, they seem to be doing good things for the state, but the implementation process is what I'm worried about. If states are actually able to develop good TMDLs, it's proven that they can be successful. But getting the state to do such a thing is what's difficult here. Section 303 only requires states to submit lists of TMDLs from time to time, literally time to time in the act. There's no other more articulated timeline to ensure that states do their part in complying with the act. There's a little bit of case law on this as well. That's the Virginia Department of Transportation versus the EPA. In this case, Virginia failed to define their TMDLs, and the EPA subsequently attempted to establish this on behalf of Virginia. It limited the flow rate of stormwater into the Accutink Creek and was designed to regulate the amount of sediment in the creek. The issue before the court was whether the Clean Water Act authorized the EPA to regulate the level of a pollutant in the creek by establishing the TMDL themselves. The court essentially rejected that and said that the EPA could not step in where Virginia's plan failed. Both parties agreed that the sediment was the pollution, but they disagreed about the stormwater that was also at issue there, and the discharges that was non-point source pollution that Virginia was dealing with. So without guidelines for the states to follow, implementing these plans is a very daunting task. After the TMDL is created, nothing in the act helps the states carry it out, and there's no timeline that the state is obligated to follow. Furthermore, within the act, there's a citizen suit provision, which allows citizens to file a civil action against the EPA administrator for an alleged failure to perform any non-discretionary act or duty. Courts have jurisdictions only over a citizen suit if it alleges an ongoing violation. This is problematic because after rainfall is over, that non-point source pollution is no longer ongoing, and a person can't bring a suit if it is wholly past. Another issue with citizen suits in general is that we're relying a lot on individuals to take the initiative to set out and take part in the claims. The Chesapeake Bay Foundation is very active in attempting to do citizen suits, but a lot of times the watermen and the very people who would be really good at arguing these cases don't have the means or the knowledge to get there in the first place. And in a lot of ways, too, watermen on the Eastern Shore are also a little bit adversarial with the Chesapeake Bay, if the Chesapeake Bay Foundation. If the foundation creates some kind of regulation or a suggestion for the bay's health that's going to adversely affect the watermen on the Eastern Shore, that's not going to compel the watermen to then work with the Chesapeake Bay Foundation to file a citizen suit. Within the same provision, this is also where it becomes the responsibility of the state government to sue the EPA as opposed to suing particular state governors. And Section 309 describes the primary enforcement options for compliance with the Act. The EPA may issue an administrative compliance order, may assess administrative penalties, may refer civil cases to the Department of Justice, or it may refer criminal cases to DOJ. The EPA is also authorized to issue a penalty that orders any person who violates specific sections of the Act or who violates Section 309 to comply with those sections. But as I previously said, all of this is limited insofar as the courts determine their own jurisdiction and the jurisdictional scope of the Act. So if the courts determine that a citizen can't bring a suit for whatever reason under the Clean Water Act, that's all barred. So in effect, a state governor can hold the EPA administrator accountable for another state's pollution, but cannot hold a violating state accountable directly. This impedes the ability of the state to protect its own water quality. The next aspect of the Clean Water Act that I'd like to bring your attention is facilitating state action. And this comes in two prongs. The first prong is that the Act provides the administrator with the opportunity to confront states regarding their pollution, including non-point source pollution and how it's affecting other states. So the administrator may call upon those states to conference to develop an agreement to reduce the level of pollution resulting from non-point source pollution and improve water quality. However, the discussion of the conferences in the Act ends a bit abruptly. There's no determination regarding how to handle cases where states can't agree on their pollution. And once the conference has been convened, the states may receive grant money from the federal government to carry out their plans. It's in the state's best interest to conference together to an agreement regarding their waters. Beginning to this is often very difficult, especially in polarized systems where many of the states have different goals and where they'd like to use their resources. The governor of any state may nominate to the administrator an estuary, the Chesapeake Bay, laying in whole or in part with the state as an estuary of national significance, and request a management conference to develop a comprehensive management plan for the estuary. The administrator would then determine if the conference is necessary, and once it's been convened, then the states would discuss. Governor Hogan, I believe, has done a little bit of this, and he does sit on a council with the governors of all the states in the Susquehanna watershed. And a lot of that has actually happened over the past 3 weeks or so. So we can also get to that a little bit at the end if you'd like. Another aspect of state action comes with Section 401, where theoretically Maryland could deny the Conowingo Dam certification. Section 401 essentially provides that if a state has the authority to review and, if appropriate, condition or veto any federal license or permitted activity that may harm water quality and the aquatic environment. The Conowingo Dam has one of these pollutions, and if the Maryland Department of the Environment found a reason to ignore the permit for the Conowingo Dam, they could do that. Now, for various reasons, that's not going to happen anytime soon. Political reasons, the reason that we have the dam in the first place. But in theory, this is a possibility. The petitioners, there have been a few positions against the Conowingo Dam in the past years and how it fits into the bigger picture of reviewing pollution within the Chesapeake Bay. In the petition, the petitioners recognize that the Maryland Department of Environment cannot rely on the Chesapeake Bay TMDL to account for the effects of climate change, and they must independently analyze the best available climate protections for the region in order to account for the impacts that we're going to see in the coming years. The Maryland Department of the Environment has a legal obligation to consider more than just a TMDL, because the agency must also analyze whether the project as a whole will interfere with the river's designated uses and the water quality standards under the expected climate conditions in the coming decades. So at the end of my paper, I've come up with a few amendments or changes that I would like to propose that would address some of the issues that I just spoke to you about. The first is amending Section 319 of the Act to require states to not only identify sources of pollution, but identify enforceable mechanisms for fixing that pollution. So whereas the Clean Water Act only requires TMDLs to be submitted from time to time, a more accurate implementation process would really help the states get moving in states that wouldn't otherwise have the political means of starting that process themselves. If a state is required to identify a mechanism for enforcing their plans, then the EPA administrator would also have something to hold those states accountable for. Leaving regulation of non-point source pollution up to the states is simply not enough. In the same way, there needs to be something driving the EPA to enforce these mechanisms. And because of polarized politics in the United States, the likelihood of a bipartisan agreement coming from a state conference is low. The EPA should not be reluctant to step in where the states fail to do their part. Section 303 should also be amended to provide more reasonable timelines for states to submit their TMDLs to the EPA. And Section 505 should allow citizens to sue the Department of Environment or similar state equivalents of states whose pollution is responsible for damage. So I digress. I recognize that the 11th Amendment has something called sovereign immunity, and citizens can't just sue the governors of other states. What I would like to see is a more specific provision for governors in states to actually take responsibility and work with each other without it being so political or polarized. I'd like to see a provision where Governor Hogan could take the authority and go straight to the governor of Pennsylvania and say, we need to do something about this now. And finally, rather than amending Section 401, the EPA should encourage states to utilize that section more often. What happens is permits are often handed out very liberally whenever a factory applies for them. They're allowed to put point source pollution into the Chesapeake Bay. And that's one of the problems that we face here is the factories being able to do whatever they want in the bay, basically. Finally, even if the act itself is not amended to include non-point source pollution, holistically, the administrator of the EPA should have the authority to designate non-point source pollution as point source pollution for purposes of regulation if the pollution substantially contributes to poor water quality. There are other acts within the United States that have similar language as this. Already in effect is an act for concentrated animal feeding regulations, insofar as the administrator is able to use relevant factors to determine that pollution of a certain type in a given area is enough to warrant additional regulation, even if that type of pollution as a whole doesn't need regulation across the entire country. The administrator would be able to come in and say, non-point source pollution on these farms in these counties is going to need a permit just like any point source pollution would need. The way that that works within animal feeding operations is that an appropriate authority, upon determining that it's a significant contributor of pollutants in the United States, determines the best way to handle and control it, and different regulations take place according to that determination. And those are my ideas.
Thanks, Rebecca. That was a great presentation. Covered a lot of ground. You're welcome to come to my class anytime you want to teach one night. But I don't mean to throw a curveball at you here, but this is actually really topical because, as you've probably seen in the press, Governor Hogan has recently directed Attorney General Frosch to file suit against both Pennsylvania and EPA. He didn't really specify what kind of claim to bring or how, but he was obviously frustrated with EPA's lack of action against Pennsylvania for not doing what it's supposed to do under the Bay TMDL and its watershed implementation plan. So I'm curious if you think that Attorney General Frosch actually has a claim, and if so, what parts of the act could it use, or is, as you said, the act so deficient that this is more or less a fool's errand?
I think the claim against the EPA could be strong, and that's exactly what is laid out within the citizen suit provision in the Clean Water Act. It allows certain states to sue the EPA administrator to step in. I'm not sure that a claim against Pennsylvania themselves is actually going to be valid. In a lot of my research, I came across the issue of the 11th Amendment in a lot of ways, because you can't just step in and sue a state governor. And that's kind of what I'm arguing for, is we amended the Clean Water Act once more to say there's this special kind of lawsuit, maybe not put it in regular courts, or circuit courts, or put it in a different kind of court, an administrative proceeding or something, to allow the states to face the governor directly. I'm also not sure that the governor himself is the best person to go to for this. I'm almost wondering if the Secretary of the Department of Environment or something like that would be more successful. Obviously, I really like the idea of going to the top of the food chain for something like this, but at the end of the day, it's the factories and it's the farmers and it's things like that that are really causing the pollution in the first place. So if there's also a way to streamline getting the message out to the individual entities in the states, that would be helpful.
Yeah, it's interesting because you've pointed out a real difference between the Clean Air Act and the Clean Water Act, because under the Clean Air Act, states can actually petition EPA to say pollution from an upwind state like Indiana is actually affecting Maryland's air and affecting the health of the citizens of Maryland, and you, EPA administrator, should do something about it. And you're right, there isn't really that mechanism within the Clean Water Act, so something like that would be helpful. Mm-hmm. We have seen states sue each other, but it's mostly over permits. So a downstream state can sue an upstream state if it tries to issue a permit that the downstream state thinks is going to be harmful. But that case, Arkansas v. Oklahoma, did not result in a very favorable decision for the suing state because it basically allowed EPA to dodge the bullet, so to speak, and nothing was really done. Plus, you end up with a direct review in the Supreme Court, which may not be the best place for Maryland or Virginia to be right now.
And I've got notes here also about the Arkansas versus Oklahoma case, because I figured that would probably come up.
Great.
In that case, for those of you who don't know, the EPA granted a permit for a new point source in Arkansas that was 39 miles upstream from Oklahoma's state line. And Oklahoma challenged the permit on the grounds that it would violate Oklahoma's own water quality standards and the TMDLs that they had for their own water bodies. And the Supreme Court upheld the permit, but noticed the discrepancy in policy interests, granting a permit benefiting one state that would in turn harm water in another state. So it's an example of how the helplessness that one state might feel in earnestly working to protect its waters, because there wasn't really another option for Oklahoma to stop the pollution because the Supreme Court said the permit was valid. Yeah.
Great. So one of the other aspects of the Chesapeake Bay TMDL that's pretty unique for it is that besides requiring all the states to develop these watershed implementation plans in 3 phases, and EPA monitoring the progress over this period of time, is that they set a deadline for 2025 to have all of the practices in place that were going to allow the states to achieve their pollution reduction goals. And EPA, interestingly enough, has recently said that that was just an aspirational goal, that it's not enforceable. And I'm wondering if you think that there actually may be another mechanism within the Act that would allow Maryland or Virginia or any downstream state to challenge EPA's action and say, yes, you have to meet that deadline.
And somewhere in the act other than the TMDLs.
Right.
That's really what I had in mind in general, is setting
To change it.
setting, mechanisms within the TMDLs. And I guess too, especially when the EPA gets involved, that's always a good thing because there's, management things there. In general, when each state has to develop a best management plan that's kind of separate but similar to the TMDLs, it requires a lot of people to step up to the plate to handle that. So a lot of states have these voluntary plans, but if a state were to do something that was involuntary or promulgate their own rule or enforce their own act within the state to comply with whatever the TMDL plan is for the Chesapeake Bay, that could also be something that could work. If the Senate was able to pass a piece of legislation that compels Maryland to actually follow through with this and not keep setting the deadline further and further, that could potentially work.
Right. Great. I don't want to dominate the conversation, so if there are others that have questions they'd like to ask.
Open it up. For asking your questions. Any questions? Megan?
So I have two questions. So great job.
Thank you.
Interesting presentation. So the first question I have is, why wasn't non-point source pollution included in the original EPA?
Yeah, that's a really good question, and I think it comes from a couple of different places. I don't know that we actually have any kind of comment from the Congress as to why they specifically left it out. I don't think that exists, but speculation would say that it's hard, it's difficult, and it's hard to put blame on one entity because of the nature of non-point source pollution coming from agriculture and stormwater runoff and coming from parking lots and gas that drips and then everything flowing into one place. It's really difficult to actually pinpoint who would be responsible for that. And along the same vein, if we were to say, so-and-so farmer is responsible for this amount of pollution, it's that farmer's livelihood too, that he's then going to have to invest thousands of dollars into figuring out something else to do with his own nutrient pollution. And that's a really, really difficult topic. And so when you're already lobbying for a piece of legislation as large as the Clean Water Act, where point source pollution is a little bit easier to tackle because it's easier to say to the factories, you're polluting, you need a permit to do that. When it comes down to the lobbying efforts for actually including non-point source pollution, I just don't think that that was a mountain that they could tackle at that time, especially because the act itself was enacted in 1947, and it's only been amended twice since then. The last time was 1987, so it's been a while since it's been reviewed.
So my second question is, what about, have there been lawsuits against the polluters? So, I mean, obviously if you have a big polluter, fine, but maybe we should be maybe Maryland should be suing all the polluters in Pennsylvania, right? And going after the farmers and going after everyone who's, or at least the major polluters who can be identified.
Yeah, that's definitely fair to say. And the Conowingo Dam, for example, is owned by Exelon, which most of us are familiar with the company Exelon. And there has been a lot of litigation against Exelon, but I think, frankly, the company's too powerful. You can sue them all they want, but at the end of the day, they can settle and they can continue doing exactly what they're doing. So you're either going to be suing a big company that's polluting a lot, that has a lot of power, that can settle these cases and then keep doing it, or you're going to be suing, like I said before, the individuals, the farmers, the people that are just polluting in their day-to-day life. And if you did sue them, it would destroy their entire livelihood. So it's a little bit like a balance of who has the means. We talk about this a little bit in remedies and in conflicts. Do you want to sue the person with a big pocket, or are you going to sue the person that can't pay out at the end of the day?
So great job. I know you have a career path already, but I think you could write a book. Really, I think there's.
I think I could too.
Yeah. So I'm really interested in what you said about the think that would be a symbiotic relationship, but it sounds like it may not be, and I can see why. So I would love to hear more about that, and if you think there are ways to find more synergies. I mean, obviously, the foundation is not the first to encounter, like, to be pursuing systemic litigation where the parties affected aren't necessarily, fully on board. So I'm just interested to hear more thoughts on that. And then you said something about, I want to make sure I understood it. So the citizen suits not being sustainable because they have to be ongoing violations.
Yes.
And I thought, I haven't thought about this in a long time, but I thought in federal court there's like the capable of repetition yet evading review.
I was thinking the same thing.
Yeah,
Like nuisances are allowed.
Yeah.
I agree.
Yeah. If you can demonstrate
The
that.
headlock is the line.
Yeah, like if you can demonstrate that exact issue will reoccur, and that every time it occurs, it's pleaded. So like in my world, in the criminal world, it's a criminal case. Every single time someone goes before the court, the court says, well, this is non-justiciable because you've been convicted or you've been freed. It's like, well, yeah, it's a different criminal defendant, the argument's the same, right?
Right.
And I think that is a way around that.
I think that that's a really good point, and I think that theoretically, with the right kinds of resources, could be a really good argument at the Supreme Court level. But I don't know that we've gotten there yet for a few reasons. One being that the Act does clearly allow suits. You just have to do it while they're happening. And because of the jurisdictional scope of the Act, different states have interpreted the Clean Water Act differently. So I don't know that we're at a place yet where every state has actually found that it's capable of repetition yet evading review, because some states find that, oh, well, there's this small exception that does allow them to sue. Some states are plaintiff-friendly in that regard. So maybe I would even be surprised if it didn't go up to the Supreme Court on a circuit split first, and then maybe that was a subsidiary question. But the circuit split, to me, seems like it's something more of a jurisdictional issue about what the Act actually covers.
Yeah,
But I think that that's fair.
It seems completely untenable that you have to file suits while the rain is falling.
Well, and think too that the Clean Water Act wasn't necessarily built for non-point source pollution in the first place.
Right.
The Clean Water Act was built for point source pollution, and that's kind of where the ongoing aspect comes in, because we're looking at whether or not there's still pollution spilling out of the pipes from such and such factory. So if the factory isn't operating anymore, that's wholly passed. But I don't know that it's even written to specifically address non-point source pollution in the way that you're suggesting. But
You're really kind, because it's all our fault. Because we, as Chesapeake Bay Foundation, tried to sue Walton and Smithfield for violating the Clean Water Act and discharging tons of hog waste into the Pagan River. And the Supreme Court said that, well, you had to prove that these violations were ongoing for citizens. Now, the federal government can file that lawsuit and get injunctive relief, make them fix it, that sort of thing, and get penalties. But because citizens can't get penalties, all we can get is injunctive relief. The court said, well, if the violation's been fixed, then you can't go backwards and then sue them. So that's kind of been the problem. What people forget is that Smithfield did have ongoing violations, and when it was sent back on remand, they actually won. So.
I also wanted to address your first question that was specific to the Clean Water, the Chesapeake Bay Foundation and citizens. A really perfect example, and you can correct me on this if you think I'm wrong, but I think is oyster dredging. Oysters are natural filters in the bay. We want lots of oysters in the bay in order for the bay to be healthy. And a big part of the economy for watermen is dredging for oysters. And so that's one example that would put them in an adversarial position, because the Chesapeake Bay Foundation wants to institute, regulations and suggestions that would say lots of oysters are necessary, but now you're telling this 24-year-old kid that he can't feed his son because he can't oyster for as many every year when it comes to be that time. So that's one example, but I think things like that come up a lot. The video I showed in the beginning of my friend crabbing is exactly what the watermen do. I don't know if any of you are familiar with how crabbing works, but you take a, 1,000-foot trot line?
Right.
About a 1,000-foot trot line, and you have one buoy on this part of the creek and one buoy on the next part of the creek, and you take your boat at 5 miles an hour and you literally crab. And they'll do this from 3 o'clock in the morning until noon, day in and day out. And so it's really in their best interest to catch as many crabs as they can in order to sell them to the commercial entities. So the more regulations we put on the number of crabs that they can get and things like that can make them really not so friendly to the Chesapeake Bay, or to the Chesapeake Bay Foundation.
Sarah?
Again, great job.
Thank you.
I think you've got great ideas for amending the statute, but I wondered if you have any perspective on the politics of that, because this week we had the first of 2 hearings essentially about streamlining, or one could say unraveling, the National Environmental Protection Act. I know that Congress last year kind of divided efforts to undercut funding to remediate conditions in the Bay, but is there any realistic chance at the moment of the kinds of amendments that you talked about, or is that kind of...
I hope so. That's a fair question, because I think a lot of my ideas are lofty, and in a perfect world, we'd love to see someone where everyone understands the effects of climate change, and everyone understands how things in the Bay are going to change over the next few decades, because they are. And I'm really hoping that it doesn't become a situation where damage control is needed. I'd really like to be able to see them being proactive in politics, but frankly, I'm not sure that we'll get there yet. Another big thing, I think, too, is awareness and advocacy about the importance of the issue in general, because in the complicated world that we live in, people aren't going to talk about non-point source pollution in their free time, you know? And that's a problem, too, because if we can get people to understand how bad this really is, if you want people to continue dining at seafood restaurants without it costing $70 a plate, you know, if you want people to be able to go out tubing with their friends on a Saturday in the summer, these are real conversations that we need to have. So to answer your question, I hope that the politics can be taken care of. I know Governor Hogan is really trying within Maryland, and this has been, so I'm working at the Maryland Senate now, so I'm seeing a lot of what they're talking about every day, and this is a conversation, and this is something that he addressed in his State of the State speech 2 weeks ago, and this is something he's really pushing for. The problem is that there are so many other things in the state that's also requiring money and time and attention. So I think the question really is, can we keep attention on this without diverting it to other things within the state?
Is there similar kind of support in Virginia?
Do you know? I don't know about Virginia as much.
Well, you may have read and heard in the news that there's been a tremendous upheaval within the Virginia General Assembly that's now been democratic for the first time, and we're seeing some really tremendous change. A lot of proposals, a lot of bills. Usually, I think they get like 1,000. They've now gotten 3,000. So, and several of them are addressed to Bay issues, and the biggest one is about menhaden and who controls the. And menhaden is a forage fish that rockfish and crabs and other organisms in the Bay feed on and are essential to the Bay ecosystem. And omega protein is one of these large, the only harvester of menhaden for dog food and cat food, basically. And they catch menhaden in these giant purse seine nets, and the tonnage of fish that they catch equals that from New Bedford Harbor, Massachusetts, and if you've ever seen Deadliest Catch in Alaska. So to think that this little tiny town of Reedville is going to catch that much fish, you have to recognize that there's significant impacts to the menhaden population. And the amount of harvest had been governed by the Virginia General Assembly for a long period of time, not by science. And so we have advocated, and others have now advocated, that that be changed, that the actual Virginia Science Board decide how much omega can harvest from the Bay each year. So we do think there is the opportunity for change, and you know, I think Rebecca is right that the place to start is not probably the federal government, but within the states. There's nothing in the statute that says that state law can't be more stringent than federal law, and we have seen that in some places, like Maryland's wetlands law is much more powerful than the now basically gutted Waters of the United States provision of the Clean Water Act. So that's where we're starting to put a lot of our resources and efforts. Yeah.
Yes.
Rebecca, you talked a few minutes ago about awareness and
that's really the key, is making people more aware of this. And it's more, it affects more people than we realize. And you have experience in your own, the last 10 years with Lake Williston. And that's a perfect example, if you want to talk about that, of how we can use something like that to make people more aware.
Yeah. For those of you who don't know, I'm a certified boating instructor through the American Canoe Association, and I spend a week out of every summer instructing young Girl Scouts on boating safety and rescue, and we do fun things too. But that's really that's really what I love is the instruction. And where we go every summer, the lake that we spend a week on is called Lake Williston, and has had really severe and tragic algae blooms in that lake as a result of some of this sediment pollution, to the point where some of these years we have all of these girls, 50 girls who are signed up to do boating for a week in the summer, and then 3 weeks beforehand, the Maryland Department of the Environment says, you can't touch this water. There was one year that was tragic. They didn't tell us in time. No one had realized that the algae was back, and we were sending girls home with stomach aches all week. And it's tragic, and it's really bad, and it's exactly those kinds of things that's not the bay itself, but that lake comes from a tributary of the bay. That's where it gets its water from. And so if that much damage can happen on a really small piece of property, imagine what people are, potentially facing when they go out on the boat in the summer with their friends. It can be scary, and I have seen firsthand what the effects of these algae blooms can do to people, and it's harmful. And I broke out in a rash at the end of that summer, and yeah, it can be really bad.
Well, in the interest of time, we'll have to end there. Thank you all for coming. I don't want you to go anywhere. We have something for you. This is Rebecca's birthday. I don't know if you this is to commemorate your Student Scholar Award this year. This is for Rebecca. We wish you a happy birthday. Thank you for a wonderful presentation. John Mueller for coming. And hopefully you can answer other questions that remain unasked afterwards. But be sure there are cakes and cups over here for Rebecca's birthday, so help yourself on your way out. Thank you again.
Thank you so much. Thank you. I appreciate it.
You did a great job.